Hello, welcome back to Class Future Lawyers. Today we're going to be talking about our second intentional tort, and that is the intentional tort of assault. So assault is similar to battery, but quite different. But like battery, it has three different elements. As a recap, we're going to start all of our intentional torts off the same, and that's by satisfying that element of intent. And how do we define intent for the sake of intentional torts? We need a voluntary act. Remember, a defendant acts out of his own volition, a voluntary act, and we need purpose or knowledge to a substantial certainty. So that's how we're going to satisfy intent each and every time when dealing with intentional torts. So the first one, a defendant acts. Two, with the intent, we talked about that. And this is what makes assault to cause a reasonable apprehension of harmful or offensive contact. A reasonable apprehension of harmful or offensive contact. What does that mean? So how do we define harmful or offensive contact? Again, going back to our definition from battery, harmful contact as in physical harm, and then offensive contact, we define that by contact that would be unwelcome, that would upset a person's reasonable expectation of their personal dignity. So then what's the difference between battery and assault? Because already we see that they have a lot of similarities, but here we have a few new vocabulary words, one of them being apprehension. How do we define apprehension when talking about the intentional tort of assault? Well, if you're following along in your torts notebook, you want to be sure to write this down in the assault section. Apprehension is defined as the awareness that an injury or offensive contact is imminent. And imminent means it can happen at any time and we don't know when it's coming, but it can happen, and it can happen right now. Like it's gonna happen and I won't have time to do anything about it. The next element of assault is the plaintiff reasonably believed that harmful or offensive contact would immediately occur. So we have the intent of the defendant to cause that apprehension, right? That thinking that the harm would be to happen at any time and there won't be anything the other person could do about it. And then we actually need that person to believe that that's true, that something is going to happen right now and they won't have time to do anything about it. Let's say I'm talking to another person in a parking lot and I have a hammer in my hand and I say, if you don't move out my way, I'm going to bash you upside the head with this hammer. And that person really thinks that I'm going to do it because I'm holding this hammer and I'm swinging in the bashing movement. As a tortfeasor, as a defendant, what is my mindset? I want them to move, right? I want to threaten them, that I want them to think that I'm going to hit them upside the head with this hammer so that they'll get out my way. And what's that person's mindset? They start shaking, they start moving because they honestly think that I'm going to hit them upside the head with this hammer because I'm yielding it and I'm doing this motion and I'm loud, I'm visibly upset. So they think that I'm going to actually hit them upside the head with this hammer. That satisfies assault. I've acted with a voluntary act with the intent, meaning that had the purpose or the knowledge to a substantial certainty that I was going to cause them to believe that this harmful contact was imminent, that I was going to go upside their head at any given moment. And that's what I wanted them to think, right? Because I wanted them to move out my way. I wanted them to think that this hammer was going to go upside their head. And they believed it. They started shaking, they started moving. Please don't hit me with the hammer. Okay, I'm gonna move. Then yes, then I've satisfied this third element. The plaintiff believed that that harmful or offensive contact would immediately occur. They believed that I was going to go upside their head at any given moment. And so again, we've satisfied all the elements of assault. Now, what's important when it comes to your exam time, it's important to know that apprehension does not mean fear. The other person does not have to be scared of me. They just have to believe that that action, that harmful or offensive contact can happen at any given time. And again, the contact can be either harmful or offensive. Go back to our definition of battery. It could be physical harm or it could be something offensive, like spitting in your direction. Even if the spit doesn't actually land on your face, that could be considered an offensive contact. Another example is if I have an unloaded gun and I pointed at someone and I said, I'm going to shoot you in your face for what you said to me. Even if the gun doesn't have any bullets in it, I still haven't satisfied the elements of assault because I said those things. First of all, I had a physical act. It's important to note that assault is not just words. It's not just words. Now, I can't just say I ought to shoot you. That's not enough. me actually though having a physical gun and pointing it at somebody, that's enough. So it's words coupled with a physical action. And so I've acted with the intent, meaning I had the purpose to cause you to believe that me shooting you in the face was going to be imminent. It could happen anytime, and it wasn't going to be too much you could do about it but try to duck. And you believe that I could shoot you at any time. You don't know if my gun got bullets in it or not. You don't know if the clip empty or not. That doesn't matter if you know. What matters is what you believed. And if you believed that I was dead serious, if you believed I had a loaded weapon, if you believed I had a real gun and that I would shoot you, then our elements of assault have been met. So to recap, when it comes to exam time, when dealing with fact patterns and multiple choice while we're looking at assault, it's important to look not only at the words, but the words coupled with the actions. Look for some kind of physical act that's being conducted, someone actually swinging a weapon. It has to be action coupled with the words to lead to our plaintiff having a reasonable apprehension that something's going to happen. And again, apprehension does not mean fear. You don't have to look for your plaintiff to actually be scared. They just have to believe that something's going to happen and that it's going to be imminent and that they won't have much time to do anything about it. So that wraps up the intentional tort of assault. If you guys have any questions, please let me know in the comments. In our next video, we're going to do the intentional tort of false imprisonment. And as always, future lawyers, see you in court.